Yes.
Adjournment request, if any, from item number 1 to 5.
My lord, item number 1, we are seeking some more time because the petitioner has failed to give us some more document. We have
All
lots of
You
RTA.
have, you have circulated the slip, adjournment slip. All right.
Deeply obliged.
31-7. 31-7. Item 6 to 16, adjournment request.
Lordship, I beg to mention item number 7 and 12. Lordship, my senior is out of station. Lordship, may kindly pass off.
All right, adjourn.
7 and 12, Lordship. We have
7 and 12.
7 and 12, Lordship.
7 and 12.
Yes, Lordship.
All right.
Your Honor,
On 30th,
1 in 2 is similar matter.
307.
1 in 2.
1 and 2. It's all right.
37.
May I please, your lordship, I beg to mention item number 11. We have taken the concern of the other side.
11.
Yes.
That bank guarantee. You are not aware. Unless you read the file, we don't even allow adjournments. The court reads the file, and therefore the expectation from the council also, even if you are seeking an adjournment. You want an adjournment?
Yes.
Have you informed the other side?
Yes.
As prayed for on behalf of?
H. Gupta.
As prayed for on behalf of the appellant and agreed to by the counsel for the respondents. Let this matter be listed for consideration on whatever date.
23-7.
Obligation.
May it please your lordship.
Or she has asked for a respondent.
No.
Mr. Banik, you are for
No. Fresh bench. May it please your lordship. May I be permitted to move a writ appeal tomorrow, madam? If
tomorrow,
lordship-
it is not possible. You can
Because-
ask for Monday,
Monday, my other side would not be there. I have word.
then you can have it on Tuesday.
Tuesday.
Tomorrow we have a lot many programs, there are many visitors and all
Obliged,
that.
lordship.
Tuesday.
Tomorrow it is not possible.
Okay.
Whenever other date, without asking for what is the urgency, we are going to fix it.
Tuesday.
Tuesday.
Obliged, lordship.
May it please your lordship, I am praying for a listing of a miscellaneous application, lordship, for restoration of a writ appeal which was dismissed for non-prosecution, lordship.
Tomorrow.
Tomorrow, obliged, lordship.
Tomorrow, though, it's not possible. Monday, Tuesday, and
Monday.
Monday,
Monday.
obliged.
Any other request? No. For admission, item 3.
Yes.
Lordship, 3 and 4, these are challenging.
We had asked you to tell us whether that circular, that OM dated 9/12/2020 was being followed pan-India.
Lordship, in my additional affidavit, lordship, that I have annexed certain advertisement where it was
I'm asking you for something else. You are answering something else. Now, we would like to know, because there could be two views. One, the terms of the contract, the contractual term of agreement, that cannot be derogated from. That is one principle which is established. The other is, because of the financial responsibilities, there has been an OM which says that there is a way in which the contractual employees would be paid. Now, the basic pension has to be deducted from the last salary and then thereafter 5% or something. There is some calculation. On the basis of that calculation, the amount has been reduced. Now, that man's, Mr. Tabildar, you are appearing for the respondent
Lordship, in both cases.
in both the cases. Now, he was not paid that amount for about 6-7 months. Now, his term of employment is over. But then the court has ordered for payment along with interest. Now, you have to tell us, there are 2-3 things. There are certain orders passed by different tribunals of the country. All such matters are pending consideration before different division benches of the court. Are you aware of all this? You just say yes. These are information which should come from you.
one case is pending in Delhi High Court, and there other issues are also there. On the last occasion, it was
No matter pending before Supreme Court.
no.
Are you sure? then we will take your undertaking, because this is a statistical fact which you will have to tell us
Lordship.
on oath, that this OM of 9/12/2020,
Lordship.
on the strength of which you have reduced the salary amount, that is not being followed. Then why pick and choose? Why cherry pick?
Not followed bola hai last time admit kiya.
वो affidavit बोलेंगे. Then in that case, otherwise there are two views. Even otherwise, even if it were being followed, we will go by what the learned single judge has said, that the terms of the contract cannot be derogated from. And that also is one of the conditions in the term of contract. It says that no, it shall not be reduced ever. Correct? So either you tell us what are you going to do, otherwise we go by the learned single judge's order. And that's all.
That whether any such case is pending in Supreme Court, that instruction at present I don't have. So
Forget about that. Now, have you reduced that amount in cases of all such army personnel who have got contractual appointment after their retirement? How will we accept? I mean, we are giving you a passage. Otherwise, it's easier for us to dismiss your appeal straight away, your writ petition. Whereas it's against the order of CAT. No.
No.
It's against the order of a learned single judge. So your appeal would be dismissed. We don't want to go wrong on law.
Lordship.
The question is this, that wherever there is fiscal connotation, it has to have the concurrence of the finance department. Now, if something wrong had been done, not that this man, the respondent was indigent or something, it's a second inning for him. In that case, whatever he has got, you cannot recover from him. But what you have not paid, can you be asked to pay along with interest? Now we are on that. Now, I told you in the beginning, there are two views. One view is to give sanctity to the contractual terms. I don't know whether she follows. आप समझ रही है ना मैं क्या बोल रहा हूँ? So what are you going to tell us? You have to give an affidavit. If you want this appeal to succeed. If you don't want this appeal to succeed, we will decide it now.
That affidavit already I have filed, but without any such order of any
No, no.
Whether
you are
same
asking application of that OM Pen India.
lordship.
What
That
is your stand in the affidavit?
in the affidavit, there is no such specific
is what
stand.
we are
That is
asking.
specific stand.
Now that is what we are asked. One pager affidavit, you have to say, that is no concession from you. Don't be afraid of,
Lordship.
of the fact that you would be accused of conceding something. No, these are facts which you have to tell us. Are you applying this?
Applying or not applying? If not applying, it will be a different view. If apply pen.
If you don't want any interference, we can dismiss your appeal, say that
Lordship,
contractual terms will.
I may be allowed further
But
time.
why not today? You should have done that. No, did we not ask you?
Lordship, that if in one affidavit.
I think in one of the orders we have said we would like to know. I'm reading
Yes,
from
Lordship.
our order.
Thereafter.
We would like to know before disposing of this appeal whether the OM dated so and so is being implemented and applied across the board in cases of post-retirement contractual employment in the armed force tribunals. And I have also limited it to the armed forces tribunals.
That affidavit I have filed without there be any such specific stand that we have applied it
So
all over
affidavit
India.
kya hua
There is
phir?
no such stand.
When you don't provide us the information, what affidavit? Why affidavit? And who appears online? Whom is he appearing for?
No, not in this case.
Next right. 2 weeks I am giving you. Take a call, and then we are primarily, let us not play hide and seek. We are primarily in favor of the judgment passed by the learned single judge. Primarily. Correct?
Only to that extent that if all over India.
As prayed for by. क्या लिखा है? मैं छोड़ देता हूँ. They are not aware. Why give them? You will not be able to bring it. And we don't want you also to concede to something. We'll go by the reasoning of the learned single judge. Let's dispose it off. When you have not given such information to us, who appears in WA number 354?
Lordship, I am appearing in both.
Both the cases?
Both the cases you are appearing. Take it. Both the appeals have been heard together and are being disposed of by this common judgment. The impugned, एक ही judgment है ना?
No, separate.
by the impugned judgments passed by learned single judge of this court in WPC number so-and-so and so-and-so, respectively, comma, the writ petitions preferred by the respondents herein have been allowed, and the appellants, Union of India and others, appellants / Union of India and others, have been directed to pay to the writ petitioners / respondents monthly remuneration of rupees 48,000 per month, as also the arrear amount along with interest at the rate of 12%, which would have accrued thereupon. The records reveal that the respondents, after attaining the age of superannuation, started getting pension of rupees 33,700 per month. दोनों का देख लेना क्या है.
Next question.
After their retirements, they were employed as consultant, junior accounts officer, on contractual basis at the Armed Forces Tribunal, Regional Branch, Gauhati, for a period of 1 year, with engagement letters dated so-and-so, after obtaining the approval of the chairman of the tribunal, New Delhi. Under the terms of the individual contracts with them, the respondents were to get a consolidated fixed remuneration of rupees 48,000 per month, but were not entitled to any other perquisites. Accordingly, as per the terms of the contract, they were regularly being paid rupees 48,000 per month. Check up the facts. Later,
One in another 80,000?
that necessary changes will do it
No,
respectively.
no.
Now, we'll not go about the
Not
facts.
so much.
Later, the remuneration was reduced on the pretext of there being in existence an office memorandum dated 9/12/2020, which provided that the fixed monthly amount will be admissible. It is arrived at by deducting the basic pension from the pay drawn at the time of retirement. The further caveat was that the amount of remuneration so fixed would remain unchanged for the entire term of contract, and that there shall be no annual increment / percentage increase during the contract period. With the promulgation of the OM of 9/12/2020 referred to above, the monthly remuneration of the respondents were reduced. This was challenged by them before a learned single judge of this court, who sustained the objection and observed that since the contractual agreement provided that the respondent would be paid remuneration of rupees 48,000 and other amount per month, and there being no mention in terms of the contractual agreement that the remuneration of the respondent would be subject to deduction of his basic pension, the terms of agreement could not have been altered by the employer / appellants unilaterally. It was also observed that the employers / appellants could not show to the court any exemplar of such deductions of basic pension from the fixed remuneration in case of any other contractual employee engaged in any other armed forces tribunal across the country. This court also sought information as to whether the OM dated so-and-so referred to above has been applied in other cases but no categorical information could be provided by the appellants. In that view of the matter, agreeing with the opinion rendered by the learned single judge in both the writ appeals, we observe that the sanctity of the terms of contract between individual persons and the employer is to be respected. And necessary consequences must follow, namely that such arrears of amount which had accrued because of reduction be paid to the respondents along with interest at the rate of 12% as directed by the learned single judge in both the writ petitions. We also say so for the reason that there is no specific averment on the part of the employer / the appellants that the OM referred to above is being applied uniformly across the board. And therefore, the respondents ought not to be cherry-picked for such reduction in their contract, reduction in their salary, about which there is a special mention in the terms of the employment that the amount so fixed shall not be reduced during the term of the appointment. Both the writ appeals, therefore, stand dismissed. The judgments impugned in both the writ petitions, in both the appeals, are sustained. Both the appeals are dismissed. We have heard Ms. B. Sharma, learned CG, your CGC, learned CGC in both the appeals, and Mr. A.R. Tahbildar for respondents, for respondents in both the cases. In both.
Correspondent number 1, there are.
Correspondent number 1.
No.
Chali.
All right.
Item number 5.
Yeah, Gauhati.
Please, my lord.
Yes.
Lord, just to put the facts in perspective, first I will draw your lordship's attention to page 45 of the petition.
45 of your petition.
Yes.
Yes.
Now kindly see, my lord. This is part of the letter dated 28/2/24.
No, we are at page 45.
No,
Just a minute.
it
Page
starts at page 43, my lord.
Oh, correct. 43.
Yes.
Standing committee meeting.
The minutes of meeting of the Standing Committee of the National Board for Wildlife is, my lord, forwarding. Now please come to now page 45. Somewhere in the middle, my lord, para 78.4.4, it refers to the proposal. Now please come to the last para. The proposal has been recommended by Chief Wildlife Warden, the State Board for Wildlife, and the state government. The animal passage plan has been prepared in consultation with the State Forest Department, scientists of the Wildlife Institute of India and user agency, and submitted along with the proposal. The animal passage plan includes 2 underpasses of over 200 meters span and 1 bridge of over 150 meters span and height of 8 meter, 9 box culvert. A slight change has to be made in the alignment. The PCCF and head of the Forest Force Assam informed that about 800 meter road length would pass about 50 meter inside the sanctuary. The Wildlife Institute of India suggested change in the alignment so that the road passes along the boundary to ensure protection for the sanctuary. There are a lot of settlements on the other side of the road. Therefore, road would provide protection from encroachment into the sanctuary. Due to the height proposed for the animal passage structures, there won't be tunnel effect for the elephant. Now, as per the minutes of the meeting, one of the recommendation was, my lord, that they should change the alignment. Instead of going 50 meters inside, for which, my lord, the tender has been called for felling of the trees, so that that can be avoided. Number one. Now, kindly come, my lord, to the decisions taken. Now, how to go about? After discussion, the standing committee decided to recommend proposal subject to the following condition. A comprehensive study shall have to be conducted by the Wildlife Institute of India or any other relevant agency to assess potential impact of the project, particularly on the movement part of the elephants and other mitigation measures. Widening of the existing NH 27 from Bosistro to Jorabad sanction shall integrate construction of at least 4 kilometer elevated road from Jorabad towards Sonapur in order to restore traditional elephant corridor connecting Amsong with the Marakhoda Reserve Forest and Aprikola Reserve Forest beyond. Now, my lord, my humble submission is I'll demonstrate from the affidavit filed by the state, my lord. This two most important, my lord, recommendation has not been followed. Now, my lord will kindly come to their affidavit filed by the state. The affidavit starts at page number 104. Now, my lord, the user
One second, let us come.
I'm sorry.
When would we go paperless? I don't know. It's so very easy to
Mr.
convert.
Goswami and the state.
Mr. Goswami, of course, it has got nothing to do with the case, but then
They have initially doing 5% duty. Everything is written, some money is returned. That's why today instructor.
no, how
Lord,
about
I'm appearing for the NHA. I'm just asking the Honorable Learned Counsel of the petitioner which minute he is referring. The date, can I know?
Earlier, I referred to
22.
minutes dated 2022, yes, of the National Board for Wildlife,
Chalo, yes.
28 to 24.
Mr. Goswami, you'll have to do something for the courts to go paperless.
Right.
Even smaller states have gone paperless. You know, it becomes very easy turning the pages. Otherwise, apart from other benefits, what paperless courts do.
I'll do
we need
whatever
to-
is possible on my.
We'll see. We'll get back to you. We'll get back to the state. Necessary
Right.
fund has to be released.
Bobo is taking over technical and.
Then everybody has to have a laptop or an iPad.
Immediately, an amount
So,
of
hardware
is writing.
The hardware is anyone. It has to be digitized.
So,
The records, what is the level, what is the stage of digitization? Anyway, we'll deal with
Mine,
it.
mine.
Page 104.
and then, no, my lord, 115. 104, the affidavit start. I'll draw your lordship's kind attention to page 115.
Yes.
Now, my lord, the user agency, that is the National Highway Authority, writes this letter to the DFO Gauhati Wildlife Division regarding compliance, my lord. Now, kindly see, in this regard, the proposal for Amsong wildlife clearance was submitted to Ministry of Environment Forest by so and so, which was returned with observation for submission of animal passage after review by the Wildlife Institute of India, Dehradun. Consequently, an online meeting was held amongst all, that is WII, state forest officers and NHA officials, concerning the clearance of wildlife proposal for Amsong Wildlife Sanctuary on 22-24. So, my lord, what was done was an online meeting. Now, my lord will kindly come to page number 121. As the proposed Gauhati ring road passes through various animal corridors adjoining the Amsong Wildlife Sanctuary, it is necessary to adopt mitigation measures to prevent any adverse impact on the wildlife of the area. According to the eco-friendly measures to mitigate impact of linear infrastructure on wildlife, the passages for elephant need to be a minimum height of 6 to 8 meters with a horizontal span of 120 to 130 meters. Also, the height of the box culvert in water bodies may have to be around 5 meters, and in other areas, the height may be around 4 to 5 meters. Now, this is important. The proposal for Angsong wildlife clearance was submitted to Ministry of Environment and Forest wide proposal so-and-so, which was returned with the observation for submission of animal passage plan with review by Wildlife Institute of India, Dehradun. So this is yet to be done. Secondly, consequently, an online meeting was held amongst WII, that is Wildlife Institute, State Forest and NHA officials concerning the clearance of wildlife proposal for Angsong Wildlife Sanctuary on 22-24. The list of the participants of the meeting is provided in this one. So, my lord, instead of physically going, my lord, an online meeting was held, my lord. This is. Now, please come to 122, my lord.
No, just a minute.
Yes.
Online is all right, but then the details of proposed animal passage also appears to have been given at phase 125.
No, please come to 122 before that, my lord.
Yes.
After the photograph, it is recommended to realign the road along the boundary of the sanctuary. Once road is realigned, the complete elephant-proof fence is to be erected to avoid venturing the elephant into the human-dominated landscape. This will also help in avoiding future encroachment of the forest land. Where is this recommendation followed? If they want to realign, then that necessity of the tender can be obviated. So, my lord, despite, my lord, there being an online meeting, my lord, even then they stick to the earlier recommendation of Wildlife Institute of India that road should be realigned. Now, they have not done that. That's why they would like to go ahead with the tender. If they realign, then there's no question of failing.
No, Mr. Chaudhary, see, you don't have to look at.
This was regarding the animal passage.
We understand the concern that trees should be felled only in extreme necessity. We understand, right? And all necessary clearances have to be taken. This is with respect to realignment of the road
And animal passage.
which enters into the sanctuary.
Yes.
Now, does it say that this realignment would obviate all necessities of elephant-proof fencing?
No, my lord.
Because
Original
realignment does not just go outside.
No.
I mean, something has to be made inside. No.
This recommendation, it is only in respect of that area which was sought to, where the trees were sought to be felled by that inviting the tender. Once it is realigned, my lord, it will go by the border of the forest. Therefore, the question of felling tree would not arise.
No. How do you say that? Unless you say that those are barren areas. No, forest.
Those are boundary. They are referring to the boundary of the reserve forest. So naturally, my lord, there is no. It can be obviated. And that is pursuant to the recommendation of the Standing Committee of the National Board for Wildlife. Page 131. For a moment,
This is not the road. This is not the- one part different culverts, then bridges over, these are other parts. They are not concerned with that. They are concerned with whether this forest going inside can be avoided through taking it realignment. That has been recommended. So they are concerned with all. Suppose it is upside down. Suppose it is taken by non-direct principal. No can't use inside the forest. There may be necessity of some these things is affordable. What is some of this? Not for inside forest. Therefore, we are out.
Yes, you're saying something, Mr. Chaudhary.
Milord, for a moment, we are not against this. All that we are trying to project is, Milord, they should realign it to the border of the reserve forest, and secondly, they should construct that passage for the elephant. Only this much.
Right. So details of the.
Otherwise, we have no complaint.
All right. So details of the proposed animal passage, what at page 125, what does
Yes.
it say?
Yes. The realignment of the road along boundary of the sanctuary with provision for an elephant-proof barrier wall, 200-meter plus open approaches of 150 to 200 meter on both sides with varying height, 200-meter plus open encroachment of 150 plus 200 meter on the both sides with varying height, detailed drainage, etc. So, Milord, they are insisting on realignment, what was suggested by the Wildlife Board of India.
Now, so far as clearance is concerned,
Yes,
about the animal passage zone
yes,
by WII,
yes.
this appears to have been made. Rightly, wrongly, alignment, felling.
They
will
said,
come.
in
No,
case
first
you do not
is
come
that.
up with that, what do we call it? Elevated road, then you must raise this fencing so that
Correct.
they cannot
Correct.
stretch
So,
the road.
so therefore, your first charge was, which was very genuine, that the clearance, the first one of the first conditions, the caveats were not met of consultation and clearance by WII, other scientific experts team and others. But this appears to have been done.
There, my lord, it is not wholly, my lord. If your lordship kindly looks at the condition, it has to be done by the Wildlife Institute of India. It is done by the user agency, my lord.
No.
Yes, NHAI. Who is forwarding this letter?
This letter is.
Yes, kindly see 115. It's a communication from NHAI, my lord. This is not done by the Wildlife Institute of India. And in fact, my lord, NHAI affidavit, they themselves admit this position. We'll come to it.
Yes.
Yes. Now, please come to, my lord, page 132, part of the same, my lord, communication, serial number 8. The state government shall strictly implement the recommendation of the standing committee, it should be standing committee of the National Board for Wildlife in its 78th meeting held on so and so. That is regarding realignment. Then a comprehensive study shall have to be conducted by Wildlife Institute of India or any other relevant agency to assess the potential impact of the project, particularly on movement part of the elephant and other mitigating measures. So this has been done by the user agency, that is National Highway Authority of India, not by, my lord, any other expert body. Then eventually at page 135, my lord.
Yes.
Last paragraph. After receipt of the compliance report from the state government on fulfillment of the conditions mentioned above, final stage to approval of the central government is accorded in accordance with section 2 of the Forest Conservation Act will be considered. Till the receipt of the final stage to approval of the central government for diversion of the said forest land from this ministry, transfer of the said forest land to user agency shall not be affected by the state government. But that protection is given.
That protection is there.
Then the Lord will kindly come to page number 138. Now this is the compliance report. With reference to the above cited letter, please find enclosed herewith duly filled annexure 2 containing the up-to-date annual compliance report with respect to our proposal, so and so, so and so. Now, if your lordship would kindly come to page 139, my lord. Please come to the first one. Terms and conditions in order of approval letter. Comprehensive study shall have to be conducted by Wildlife Institute of India or any other relevant agency to assess the potential impact of the project, particularly on the movement path of the elephant and other mitigating measures, blank. Number 2, widening of existing NH 27 from Bossis to Jorabad section shall integrate construction of at least 4 kilometer elevated road from Jorabad towards Sonapur in order to restore traditional elephant corridor connecting Amsong with Marakoda Reserve Forest and Aprikoda Reserve Forest and beyond. As on date, no upgradation is proposed beyond Jorabad. However, same will be considered during upgradation. So how, my lord, the government can file an affidavit and say that they have complied with all the requirements, my lord?
Mr. Goswami,
My lord.
why is there no statement from your side with respect to any adverse impact or for that matter, a comprehensive study? Those columns, correct, this is from National Highway, but they give you the information.
It's already there, page 11, 15.
Okay, let him complete first.
Yes. Then, my lord, kindly come to the final approval at page 146. This is by Ministry of Environment and Forest.
Climate change.
Kindly come to that, my lord, sir, madam person. This has got reference to the state government's online proposal on subject seeking prior approval for the central government under section 2 of this one. So, and to say that the proposal has been examined by regional empowered committee constituted by central government under section 3 of the act. After careful consideration of the proposal and recommendation of the REC in its meeting held on 29/4/24. In principle, approval was granted by this office letter of event number dated so and so, subject to fulfillment of certain conditions. Then my lord will kindly come to the next page.
This one of the proposal for diversion of certain area of forest land for construction of ring road,
Yes,
including bridge.
Yes.
They say that in principle they approve of it.
yes,
And widening existing NH 27 from buses to Jorat section in this subject to the following conditions. And what are these conditions?
yes. Please come to my lord next page as 147, my lord. 1.6. State government shall strictly implement the following recommendation of the Standing Committee of National Board for Wildlife in its 78th meeting held on 22nd of February 2024. A comprehensive study shall have to be conducted by Wildlife Institute of India or any other relevant agency to assess the potential impact of the project, particularly on the movement part of the elephant and other mitigating measures. Widening of the existing NH 27 from Bossis to Jorabad section shall integrate construction of at least 4 kilometer elevated road from Jorabad towards Sonapur in order to restore the traditional elephant corridor connecting Amsong Wildlife Sanctuary and Marakoda Reserve Forest and Aprikoda Reserve Forest. Then, my lord, no adverse impact shall be, etc., etc. So, my lord, they are insisting on those conditions. That means you cannot, you have to realign, and secondly, you have to construct the corridor. And the comprehensive study. These are the three, my lord, components. And my lord, the NHI's affidavit is also very clear. If your lordship kindly takes the
No,
affidavit.
therefore, in some substance, your argument is
Yes, my lord.
that one of the necessary conditions before work could have started
Yes,
was a comprehensive study
number one.
by either WII or any other relevant agency.
Hmm.
Number one.
Number two, realignment. And number three, my lord, 4 kilometer. These are the things. Otherwise, we welcome this project, my lord.
Widening, shall integrate construction for realignment, no adverse impact, minimum tree felling, no construction activities.
In that meeting, recommendation of that meeting, strictly.
कर रहा है ठीक है देखिए ये without the elevated road this will only help the elephants from being trampled. जो रेलवे वाला लाइन वहाँ पर जो देखा था जो realignment कर सकता है तो now realignment करता हूँ इसको इधर का नहीं करता instead of immediately cutting what is the necessity to cut all this today not to do it so. Yes, Mr. Goswami.
Hello, page 115 of my affidavit.
Page
115. By this letter, my lord, the earlier decision was basically communicated by the NHA to the DF of Gauhati Wildlife. It says, my lord, you kindly see. This is basically regarding submission of wildlife access plan. The subject itself says, in the body it says, my lord, in this regard, if the proposal for Amsang wildlife clearance was submitted to MOEFCC by proposal number so and so, which was returned with observation for submission of animal species plan with review by Wildlife Institute of India, Dehradun. Consequently, an online meeting was held among WRI, state forest officials and NHA officials concerning the clearance of the wildlife proposal for Amsang Wildlife Sanctuary. So let us, my lord, turn to the next page. That is the, my lord, basically the discussion, meeting and the decision taken, my lord. If, my lord, we turn to page 121, my lord. The first part, my lord, has already gone through, my lord. Third paragraph, I would again like to read, my lord, 121. The proposal for Amsang wildlife clearance was submitted to MOEFCC by proposal number so and so, which was returned with observation from same quoted, my lord. Now, my lord, will kindly see one thing: protected and ESZ zones. It is submitted that the protected and ESZ zone of Amsang Wildlife Sanctuary lies at the following chain edges along the alignment of the Gauhati Ring Road. There are 5 chain edges. Now, my lord, thereafter, my lord, it says PCCF and HOP welcome all parties so and so. Next paragraph, my lord. PCCF so and so wildlife Gauhati briefed about various locations of the elephant corridor across the Amsang Wildlife Sanctuary for which an animal passage plan was required in the proposed Gauhati Ring Road project. It is irrelevant, my lord. There are 3 critical areas under observation in the proposed Ring Road project. That is from chain is 32 plus 200 to 32 plus 900. Chain is 37 plus 100 to 37 plus 900, and chain is third one. Now, my lord, what they have done, my lord, they have deliberated one after another chain as well. Separately, they have deliberated on the chain edges. These are, my lord, critical areas. Number 1, after detailed deliberation, the following was resolved in respect of each location. It is location specific. My lord, this is the deliberation about the first chain edge, my lord. Here, my lord, will see in the next page, after the map, my lord, what was recommended by Wildlife Institute of India. It is recommended to realign the road along the boundary of the sanctuary. Once the road is realigned, the complete elephant-proof fence is to be erected to avoid venturing the elephant into the human-dominated landscape. This will also help in avoiding future encroachment of forest land. This was as regards the section 1 is concerned. First chain is. Second chain
is. This is with regard to chain number 32 plus 200 to 32 plus 900.
Exactly.
So has that been done?
Yes, well, that has been done. It is already there, man. In respect of chain is 2 and 3, my lord. The rest of the 2 chain is. There are other suggestions which were also accepted, my lord. If I may read, my lord, second.
No, you say that you have realigned the road along the boundary of the sanctuary.
Exactly. Turn to page 125. If we turn to page 125, my lord, will see details of the proposed animal passages. In respect of chain is 1, 300, 32 plus 200, 32 plus 900. realignment of the road along the boundary of the sanctuary with provision for elephant barrier wall. What they are asking for, that we are precisely doing that, my lord. That realignment is done, but in respect of changes 2 and 3, the realignment proposal was not from the Wildlife Institute of India. So whatever the proposal they have made, my lord, suggestions, we have accepted. Now, if we go, my lord, they say it's a document forwarded by the NHAI. If we turn to, my lord, page 127. List of participants of the meeting held on 22/2022 online. Forest Department, Government of Assam, so-and-so PCCFs, so-and-so, Wildlife Institute of India, Dehradun, Dr. Bilal Habib, scientist. These are National Highway Authorities officers, man. So it was a joint decision. It's not that Wildlife Institute has suggested and we are not following. We are following. In respect of changes 1, realignment has been done. And precisely that was the suggestion, not in respect of our entire area. And my will kindly appreciate one thing, out of 7 hectares, but we have to only touch 450 trees. I have instructions to submit, those trees are basically tree bushes and fruit plants,
These bushes are
small tree bushes and fruit plants are there,
fruit plants.
Fruit plant. And for that, there is Kempa project is there, compensatory afforestation will be done. For that 7 hectare, we are replanting in 15 hectares in a different area, And if will see what they are saying that comprehensive study has not been done. If peruses the affidavit filed by the NHAI for a moment,
Yes. NHAI, the difficulty is that NHAI is a user agency. NHAI,
Yes.
आपकी affidavit चाहिए.
In fact, we are in the same tune,
We need your affidavit. NHAI to
Project has not comment. We have floated a tender for management of these trees. Page 27 of the affidavit, paragraph 9.
where do we get it? Page, running page?
My affidavit says this. 22 it starts. Yes, go to the page 27.
Ministry of Environment कहाँ पर? इसको कहाँ है? National Board for Wildlife.
हाँ, ये दोनों का
दिल्ली में
से क्लियर हो गया, हाँ।
ये clear कर दे तो.
क्लियर कर दिया हूँ।
Who appears for respondents number 2 and 3?
दोनों साइड फाइट कर रहा है, फॉर्म है नहीं है। Comprehensive study. आपसे बोल देंगे तो decision
Who appears for respondents number 2 and 3?
Union of India, my lord, I think Mr. Pegu, he appears.
Mr. Pegu is here.
One more thing, that page 27 of the.
No, we are not stopping you. We were only looking for Mr. Pegu. Chalo.
Yes, on that comprehensive study, page 27 of the NHAI affidavit. This is the present status.
We'll like to know from you the running page.
Page 27, as per my copy, they have started on me.
27 was for him.
starts I'll tell you, sir. Respondent number 8.
8.
NHA respondent number 8.
Yes, lordship.
Page 176.
That paragraph 9, my lord will find.
Yes, lordship. We have given the compliances made by NHA.
Paragraph 9, my lord will see. That the table below indicates the preconditions which was to be fulfilled in terms of the recommendation for 78 meeting of the Standing Committee of National Board for Wildlife, held on so and so. Regarding comprehensive study, my lord, a comprehensive study shall have to be conducted. This was the requirement, my lord. Forest Department requested Wildlife Institute of India for carrying out the said study and requested NHAI to bear the cost of the study to be conducted by Wildlife. NHAI has undertaken to bear the cost of the study to be carried out by. It will be done, my lord. We are not saying it will not be done.
No, no,
We have
no.
not commenced the project.
The contention of Mr. Chaudhary is that before you start doing anything, these are essential starting points. They say that you have to do your study, the impact, the harmful impact, Forest Department, of course.
Mr. Goswami, suppose after comprehensive study, they say they know nothing doing, no tree cutting, you have this alignment like this, then what?
In the meantime, in principle approval also have been granted,
Yes,
my
in-
lord, on that same
In
realignment.
principle is subject to condition, and one of the condition is comprehensive study.
Yes, ma'am, that will be
Then-
done. That will be done, but
That will,
alignment is already confirmed in the.
no, after comprehensive study, if it is said that no tree cutting, it alignment is something different, then.
What it says, my lord, comprehensive study of work shall have to be conducted by the Wildlife Institute of India or any other relevant agency to assess potential impact of the project, particularly on the movement of parts of elephants and other mitigating measures. So on the parts of elephants, well, we are constructing overpasses, madam.
That we understand, but this is without the study.
Well, in fact, the idea that I have shown, my lord, the Wildlife
Sir.
Ministry of India was also a party. They have suggested certain things. My lord will kindly see. Page, my affidavit, page 121 starts. What are the suggestions in the aspects of others? My lord? Page 122, my lord.
Lordship, may I clarify on one point, Lordship, about that comprehensive study, Lordship, because it is related to this elephant corridor, Lordship.
Yes.
That will be required substantially while constructing the underpasses, Lordship.
Will have to be conducted
Page
by the
120,
wildlife
madam.
Ministry of India to assess the potential impact of the project, particularly on the movement of path of elephants and other mitigation measures. Yeah, this cannot be a first thing.
Lordship, in that case, Lordship, on these 2 points, like comprehensive study and the realignment, Lordship can give us a short date. We'll come back, Lordship, explain it.
No, we are not understanding this. Now, are you suggesting, Mr. Counsel, for an HAI, are you suggesting that only if the underpasses are made, thereafter it will be subjected to the study of for assessing the
No, I'm
impact?
not resisting that, Lordship. I'm only saying that this precondition actually is related squarely to the underpasses of elephant corridor. Lordship, on that, I'm saying that probably it will be it will have an implication while constructing that, and that stage comes later, Lordship. Probably that's why
Suppose, God forbid, if the Wildlife Institute of India on expenses incurred by NHAI
Lordship.
finds that this movement path of elephants would be harmful, let it remain as it is, then what do you do?
Therefore, that is the reason, Lordship.
Therefore, we get a feeling that you are possibly understanding it
Yes, Lordship.
as a post-construction assessment and then suggesting mitigating measures. I don't think that was the intention.
I fully understand, Lordship, what is coming from you, Lordship. That's why I'm making a request. Can you give a short date? We'll come back on these 2 points about the comprehensive study, because it is a 2024 minute. And what is the status right now? I haven't included in the affidavit. So can I come back in a short date and explain these 2 things: realignment as well as the status of comprehensive study, Lordship?
So till date, today, you're not aware of any report after the study.
Lordship,
that
otherwise
correct?
I would have annexed it along with this my affidavit, Lordship.
Do it. We give you time. Mr. Pegu. Now, Mr. NH, what is your name, Mr. Counsel? It doesn't
Lordship,
look
I'm
like.
Devojit Bor Kakoti, Lordship.
क्या नाम होता है?
Devojit Borka.
Bor Kakuti. Mr. Counsel, for I would not remember your name. For NHI, you see, he says something is the state. Now you have to tell us whether all the preconditions have been met. You certify. Where is your affidavit?
And whether they can go with the tree cutting, that's all. This is the cutting of the trees, not other.
You satisfy. See, we will not be an impediment under any circumstance in any national project. We are making it very clear. But you are the one who would insist that there should not be any unnecessary felling. There should not be any harmful impact. Correct? So where is your satisfaction? You tell us. So you file your affidavit. You file your affidavit. Now, Mr. Goswami represents the state of Assam and the department. Say that he has done his part. Now you have to be satisfied. You are the nodal department.
Is that cousin?
NHI, of course, NHI would be the user agency. Every time we would catch hold of his neck only if he goes beyond.
In the Forest Conservation Act, they are the supreme authority.
They are the authority.
Otherwise, Lordship,
Yeah,
para
they are
5
very,
of my
very
affidavit,
clear.
I have given detail of the host of measures we have taken, Lordship, in the
So
para 5.
whatever you have done, if that satisfies them that this is done, they can go ahead. Fine.
We have
You-
no difficulty. See, look at our approach.
Yes.
Look at the approach of the petitioners also. They don't say that this project is bad. No, not at all. They started with this argument that this project, traffic, everything is necessary.
Lordship.
And therefore, incidental damage, if it could be controlled as far as possible, so far so good. But there has to be some study, some check, some balance. Otherwise,
Lordship,
you can't go through the middle of the forest
We cannot.
on some
I
pretext
appreciate
or the
Lordship,
other.
on these 2 points, let us
After
come back.
this, then we'll have to propose another elevated corridor like Kaziranga.
Correct. So, Mr. Pegu, you've put in your affidavit. Mr.
Debojit Bhagavati, Lordship, for NHA.
Mr. Debojit, you also have to get back to us with
Yes,
specific
Lordship.
information, whether any comprehensive study was undertaken, and if any study was undertaken, what is the report?
Lordship, I'll come back.
Study in the mind and personal computer of the scientist would not satisfy us. There has to be a report on pen and in black and white. Then only we know. And they say that no, please go ahead. The impact would be minimal, which cannot be avoided. We'll not question it even for a second.
We'll do
not
it.
question it even for a second.
That is what
We'll do it.
what we call sustainable development.
If there is, 12.
नहीं, उसके बाद देखिए।
Will your Lordship give us a time frame, Lordship?
Just a minute. We are just going through our earlier order.
Yes, Lordship. I'm so sorry.
Now, on the last occasion, we said that the major concern of the petitioners today is that according to the information they have, the mandatory forest clearance under the Forest Conservation Act has not been granted by the central government. This we are keeping under we are keeping it in abeyance for the time being. However, the Divisional Forest Officer, Wildlife Division, has already issued a e-tender for selecting a contractor for felling trees inside the sanctuary. Such action is dubbed as post haste, and if it allowed to go through, it will cause irreparable damage before any proper scrutiny by the concerned authority is made. Correct? So, now the thing boils down to the comprehensive study
Yes, yes.
and their report.
Yes.
Now,
Lordship.
bring it on record. We give you a go ahead from our side.
Okay, Lordship.
देखिए Mr. So-and-so, Mr. Debojit, पूरा नाम लिख लेना. Mr.
Bor-
Debojit
Borkakoti, Lordship.
Borkakoti,
Yes, Lordship.
learned advocate for NHAI, seeks some more time to file additional affidavit in this court about all clearances have been taken before proceeding ahead with the construction of the ring road.
Lordship can say specifically about the comprehensive study, Lordship, because otherwise we have given other clearances.
As also a report of the comprehensive study by Wildlife Institute of India or any other specialized agency to study, to assess the impact of the project.
That was the condition.
Particularly with respect to the corridor, particularly with respect to the movement corridor of elephants. Stop. Mr. PEGU, Learned Counsel for Respondents number 2 and 3, shall also file clear affidavit stating that all the prerequisites for starting the project have been met, and if not, the reasons for the same, and by what time such conditions shall be fulfilled.
Gotcha.
In the meantime, Mr. Goswami, learned senior advocate / additional advocate general, State of Assam, submits that no trees shall be felled.
Otherwise,
I have
it's
already
no,
given that understanding.
otherwise there is no urgency right now.
Presently,
Yes,
NHCI
presently.
has some urgency, my lord, but forest doesn't have
Forest
it.
doesn't have.
Because we are also concerned with the trees.
All of us require greenery.
17th June.
No, see, there is no hide and seek. This national project, it's a big project, mega project for the state of Assam. It will have many advantages, no doubts about it. We are not going to be an impediment even for a day.
Yes.
But then these things should be met so that you don't fall in trouble in future.
Yes. In my village, I have planted 2,000 trees, courtesy to Forest Department of Assam. They have big nurseries, whoever is interested can go there and collect those plants.
I'll borrow some from him.
Yes, definitely.
Yes.
And some plants were provided for this urban code also.
We have not given a date. June बहुत late हो जाएगा.
Definitely
June would be too late.
Yes,
No,
Lordship.
you-
Yes, Lordship.
18th or 19th of May. madam.
Correct, 19th of May.
Lordship. Much obliged, Lordship.
19th, 18th को हमारा 19th of May, yes.
19th.
Obliged.
Diploma.
Much obliged.
Item 6.
ठीक है.
Said inserts.
Hmm?
Said inserts between fellow.
Compulsory को.
It does not also for great placement.
Yes. इसको लिख देना.
Made friends, Lord.
Yes.
My lord, here.
Did we say anything on the last occasion? No, it was adjourned. Yes.
No.
The punishment of removal has been reduced to compulsory.
My lord,
Yeah, Mr. Bhattakur, you'd be happy if the same thing is.
No, my lord.
We don't wish to interfere.
My lord,
It may not be as shocking to the conscience as the conditions in the service jurisprudence has been laid out to be. But
Right.
then it's an overall responsibility for the shortage. You pick up one and you remove him from service. So therefore he says that, well, he is not to be retained in service, correct? But compulsory retirement, that's a major punishment.
my lord,
And if the single judge has come to such a finding, then why do we interfere with it? Now,
But-
Ranjit Thakur
right.
or what is that name? What is that name?
Kakkar, my lord.
Ganayuthan.
No, there are
Now, if
many,
you
my
go
lord.
strictly by those principles, if it shocks the conscience, what would shock a conscience? Dismissal and removal does not shock the conscience.
But my lord.
The punishment is, I mean, the whether the offense is such
my lord,
where you have not been able to find out the joint responsibility of the entire depot. There has been a shortage.
No, my lord, there are other employees also taken.
Had it been reduced to some, only monetary punishment, we could have understood. For that,
No, there are
there is,
compulsory retirement also.
we do appreciate that the
There are
learned,
other.
just a minute, the learned single judge did not give any reason. He only says that at this stage, we do not find it appropriate to remand the matter to the disciplinary authority for writing out a fresh order of punishment. I mean, that's the only place where reasonings have not been given.
Primary.
Why
rules
not?
are taken. Lordship will kindly, I just draw your lordship to one order of the appellate authority. Appellate authority has taken into consideration that. Lordship kindly come to.
Mr. Roy,
Lordship.
any other judgment on this said inspector's punishment and all by us?
Yes, my lord.
In
one-
fact, we have
One judgment is there. Lordship did not interfere. That was compulsory.
So this time also, I think without us being reminded, we are
No,
consistent.
that was my lord, under different facts.
Different facts,
Different
but
fact,
same
but
ground
that
that
was-
would not be identified for whose fault and all. Many
No, my lord,
persons
it was, there it was found access. Here is shortage. There it was found access. Lordship, the appellate authority has passed an order
reasoned order saying why this punishment. Therefore, my lord, this aspect ought to have been considered by the single judge. This is my humble submission. My lord, it's true, my lord, the court can reduce the punishment itself. Also,
It's not that.
but normally the court doesn't interfere, my lord, with the quantum. The lordship will kindly, the appellate authority has passed an order, said if the lordship will kindly come to page 112.
Oh.
My
1987,
lord,
1987, 4 SCC 611. This is Ranjit Thakur. And then
yes.
Union of India versus G. Ganayuthan, 1997, 7 SCC 463. निकाल कर देखो मैम. Which page are you referring to?
My lord, the appellate order, page 110.
Tell us the paragraph or the internal page.
Page 11 relevant. And the 112, in fact, 111 last para. Now after careful, this is an appellate order.
No, the internal page of the judgment. We look at it not from your.
We're saying about the appellate authorities order.
Oh, where is that?
110.
Yes.
The lawsuit got 111.
Yes.
Now, after carefully
111 now.
going the facts of the case sequence of events, the report of the incorporated disciplinary authority and appeal of the charge of it, the undersigned concludes that so and so, the then shed number 2, was indeed fully responsible for charges brought against him, and the undersigned does not find any valid reason for ground to defer with the so and the penalty imposed disciplinary authority, and that any reduction in the penalty imposed disciplinary authority would seriously harm the corporation and by way of loss and wrong message would go to the. After all, there's given a definite, my lord, reasoning, my lord, lordship, this aspect of the matter, Learned Singh did not go through. And my lord, what is the charge, what is the finding, my lord? There altogether, my lord, 3,944 bags were found missing within 22 days. And the food grains are kept in stacks. Out of 3 stacks, 2 were found missing. 2 stacks were found missing. So this is a very serious thing, my lord. Therefore, 3,944 bags within 22 days. This is the finding of the disciplinary authority or as well as the, and the Learned Singh did not interfere with the finding of the inquiry officer and inquiry proceedings. Found everything right.
Chart back. He says it is unproduced.
What is your judgment? Earlier judgment.
नंबर तो
Very good. We are not interfering. We have heard Mr. नहीं करते हैं, देखें. Yes, he was left to go. He has served for 34 years.
I have already retired, Your Worship. In 2016 itself, I have retired. During the pendency of the writ petition.
During the pendency of this writ petition. Strictly speaking, sentence को कुछ change नहीं है. Remember,
1/12/2015.
Later. We have heard Mr. P.K. Roy, learned senior advocate, assisted by Mr. S.K. Chakravarti for the appellant / Food Corporation of India and 3 others, and Mr. S. Thakur, learned senior advocate, assisted by M.S.P. Bora, learned advocate for the respondent. The appellant / FCI and 3 others have questioned the judgment dated so-and-so, dated 22/5/2024, passed by a learned single judge of this court in WPC number 4423 of 2012, whereby the decision of the disciplinary authority in finding the respondent responsible for the shortage of food grains in the FCI shed was upheld, but an interference was made with respect to punishment, and the punishment imposed upon the respondent of removal from service with forfeiture of gratuity was interfered with and reduced to compulsory retirement with no forfeiture of gratuity. The respondent at the relevant time was the in charge of a FCI food godown in his capacity as assistant grade 2 officer. He was served with a charge sheet with the allegation of causing shortage of about 4,000 bags, which amounted to loss of approximately 2,000 quintals of food grains between July 2010 and September 2010. The disciplinary authority did not agree to the reply of the respondent in the departmental inquiry which ensued, the charges against the respondent was found to be fully proved. He was thereafter subjected to the punishment of removal from service and forfeiture of gratuity. The appeal preferred by him before the statutory appellate authority was dismissed. The learned single judge, the contention raised on behalf of the respondent was that he had had an unblemished record of about 34 years in the FCI and had discharged his duties with full responsibilities which were bestowed upon him. The ground of challenge was that there was no finding of misappropriation against the petitioner. The inference of misappropriation was made only because of the proved shortage of food grains. Shortage of food grains. He was the shed in charge the district officers in the district of Silchar. He was not the only person who was responsible for managing the shed or for its maintenance. At the relevant time, there were many other officers working who, along with the respondent, also shared similar responsibility. What was harped upon by the respondent was that it was the collective responsibility of all the officers towards the maintenance and supervision of the FCI shed in question. The further ground of challenge before the learned single judge was that forfeiture of penalty is not listed as one of the major punishments, and such punishment could not have been imposed upon him. That apart, it was urged that even in accordance with the circulars issued by the Food Corporation of India, there was an insistence on the adherence of procedural formalities in cases of shortage and transit loss cases. Such circular was issued in the background of serious resentment by the employees in the event of any shortage of food grains which was being noticed. The experience in the past had been that only one or two employees were picked up for being proceeded against without caring for the collective responsibility and therefore the collective culpability. Circumstances, the circular was issued to all concerned authorities that no recovery should be directed with respect to storage and transit losses without definite finding of either theft or pilferage or of malafides of the proceedings. In the present case, the respondent had argued that every responsibility was thrust upon him on the ground of finding of shortage of huge quantity of food grains, which was detected during audit. But such shortage was not specifically stated to have been caused within a short period, but those could be relatable to a longer period, which also could be attributable to lack of proper maintenance of the shed. No evidence came forth with respect to any theft or pilferage or any malafides on the part of the respondent or on the part of the respondent. The learned single judge, after hearing the parties, was of the view that before him there was no effective challenge to the conduct of the disciplinary proceedings, nor was it alleged that the proceedings were carried through against the respondent in breach of the procedure prescribed in relevant regulations. There were no infraction of natural justice, which was very obvious from the perusal of the inquiry report. What was argued before the learned single judge, it was observed, was that there was no fact finding with respect to any misappropriation by the petitioner or any loss having occasioned because of any overt irresponsibility of the respondent in his capacity as shed in charge. The learned single judge did not agree with the submissions of the employer of the disciplinary authority that conclusions of theft or pilferage or misappropriation leading to loss of food grains and consequent financial losses can only be arrived at on the basis of inquiry and evaluation of facts and materials which are available. The learned single judge found such inferential guilt fixation in accordance with the principles of service jurisprudence. There had to be specific finding based on evidence with respect to either theft or pilferage leading to loss of food grains, thereby causing financial losses to the FCI, for the respondent to have been subjected to the harshest of the penalties of removal from service and forfeiture of his gratuity, without having taken regard, without having kept, without giving due consideration to the fact that in the last 34 years, there was no complaint against him from any quarter, and that the losses could have been caused over a period of time when he would not have been the in charge of the shed in question. While postulating that a writ court cannot act as an appellate forum for reviewing the punishment imposed upon a proceedee, and that its jurisdiction only pertained to examining the process of decision making by the inquiry officer and by the disciplinary authority. But in the present case, the way punishment was imposed upon the respondent did not find favor with the learned single judge. The report of the inquiry was thus left untouched because nothing could be shown on behalf of the respondent that rules of natural justice were not complied with, or that the findings or conclusions were not based on evidence except for the cause of such losses. Cause of such losses. Full stop. Under such circumstances, the learned single judge found that for the punishment to be condign, 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 it was necessary to reduce it from removal to compulsory retirement and doing away with the punishment of forfeiture of gratuity, as that is not one of the punishments listed in the rules. And which was also subject to separate statutory restriction, subject statutory prescription / restriction, namely the Payment of Gratuity Act 1970, जो भी है वो लिख लेना. On the issue of remanding the matter to the disciplinary authority for passing a fresh order with respect to punishment, the learned single judge was of the view that for the efflux of time, it would not be appropriate to do so. The court itself proceeded to make alterations in the sentence. Mr. Royal and senior advocate for the appellant, while assailing the judgment, impugned submitted that perhaps the learned single judge has substituted his own views regardless of the reasons given by the disciplinary authority and the appellate authority about the reason for giving the harshest of the punishments to the respondent. One being that it was necessary to send a message across the employees to be careful in future. This could be no reason to justify a punishment, because the principle enshrining the imposition of punishment is that it should not be more drastic than is necessary. The second argument raised on behalf of the appellant / employer was that punishment of removal cannot, in the aforementioned factual circumstance, cannot be said to be shocking to the judicial conscience. And in that case, no interference ought to have been made. There is no gainsaying. That the role of courts / tribunals is purely secondary in cases not involving fundamental freedoms. so far as proportionality using punishment is concerned, normally the Wednesbury test is to be applied to find out if such decision is illegal or suffers from procedural improprieties, or is one which no sensible decision maker could, on the materials before him and within the framework of law, could have arrived at. So the courts are but perfectly entitled to consider whether relevant materials had been taken into account or whether the decision making was based on irrelevant matters. The court can also consider whether the decision was disproportionate, absurd, or perverse. Before, it has been held, and the same line of reasoning is applied even today, that a court would not normally go into the correctness of the choice made by an administrator amongst the various alternatives open to him, nor would the court substitute its decision to that of the administrator. But in case it is found from the facts and circumstances that the punishment imposed upon a proceedee is disproportionate to the guilt arrived at, a court would be entitled to interfere with the same. In strictest of the terms, a sentence imposed upon a proceedee could be described to be irrational only if it is in outrageous defiance of logic. However, a question always confronts the courts as to the parameters on which the issue of proportionality could be judged. The essential facts of the case, the conduct of the proceeding, the losses having been caused to the employer, the nature of charge, the stage of life of the proceedee, any other factors would have to be taken into consideration for testing the proportionality of the sentence imposed upon such a proceeding. In our estimation, with the respondent having retired during the pendency of the writ petition preferred by him. And having served for 34 years without any charge leveled against him. And there being no specific finding of any theft or misappropriation or malafides on the part of the respondent, we are not in a position to interfere with the reduction in the sentence by the learned single judge. We say so also for the reason that the proceedings the proceedings against the respondent was started about 16 years ago. For the aforenoted reasons, we approve of the finding / opinion of the learned single judge, which does not, first of all, we have not been persuaded to take any different view of the matter. The appeal thus is dismissed. यहाँ हम वो सब लिखाए हैं, जहाँ question of proportionality लिखाए हैं, वहाँ पर लिखना refer to Ranjit Thakur 1987 4 SCC 611, Ranjit Thakur versus Union of India, then Union of India versus G Ganayutham, Jagannath Rao का जगह है, बहुत बढ़िया, 1977, 1997 7 SCC 463, उसके बाद वाला लास्ट कौन सा है? We have some case ना, Raj versus Heem Singh and 2020, not more drastic है ना? Kumar versus India. So, all the refer to sons dismissed.
Same principle.
All. खत्म कर दे, ठीक है? नहीं चलो खत्म करते हैं.
Item 8 to 10.
Amendment वाले.
Please, your lordship.
My colleague, senior colleague has informed that they are not going to praise upon the impugned eviction notices issued against us on 26/11/2021. In that case, the item number 8, where I have challenged, had become infractious. So if that goes, that the rule which I have challenged, that I was contending that you cannot issue those notices. For that, I will require one indulgence, your lordship accommodate, that at lunchtime, I will have a talk with my clients. And
Whether you want to pursue it.
yes or no?
I think the better option, if they are not evicting you, just don't stoke fire.
Yes, madam. Absolutely, absolutely.
That's better. Take instructions, come back to us. If you want to withdraw, we will.
Yes, I will do that, because one of the client is here, but they want to discuss with the Gaubura. So let me.
Next week, kar de. Come with a clear instruction.
Absolutely, madam.
We are placing all these matters. ऐसे लिखिए. Mr. S. Borgohain, learned advocate, appearing in these matters, submits that there could be a possibility of the petitioners not choosing to pursue these petitions in view of an assurance given to them that they shall not be evicted from the land over which they had been residing. First up. He will take clear, he says, he seeks some time to take clear instructions of the matter before making a definitive disclosure before this court.
Not assurance, not.
earlier
Those notices, eviction notices.
They will, no. All right. Tuesday, 19th.
19, my lord.
तो मंडे का है 11th 12th कर दो 11th
Orders में दे दीजिए.
11th.
Listing orders for Monday. सुबह से कम होगा.
11th correct yes
Earlier notification, we have issued matter settlement of in person that we are not taking any steps for eviction.
we have not even referred to your statement. He says so. Yes. We have carefully not said that you have agreed to it.
No, on his assurance I am coming, my lord.
That's what the record is. Already,
Anyway, you choose your words carefully on the next date when we will permit you to
Exactly,
withdraw.
my lord.
Yes. yes. Where is it? Item number 13. चलिए खत्म करेंगे आज हमारा पानी पिलाओ जरा.
Union of India is not there.
कहाँ लिखा हुआ है?
PA.
Oh, we have fixed it at 3 p.m.
My lord.
3 p.m. We will not wait for this only. We have some other words. You argue your case. Who appears for the
Union of
Deputy
Union of
Solicitor,
India?
my lord. We have informed that it will be coming up. I believe my colleague was here also.
Item 13.
43D5
My lord, your lordship.
through backdoor.
My lord.
The constitutionality through inference constitutionality has been affirmed.
My lord, your lordship will kindly appreciate two things.
Yes.
First thing is that the lordship was clear that I have given a compilation from right from Jahur Ahmed Shah Watali till the Gulfisa Pati Mother Delhi riot case. Nowhere they have assailed or challenged the virus of
No,
petition.
they are not questioning you on your propriety of filing this petition.
My lord.
They are not questioning your propriety of filing this petition. We understand. There it was a question of agreeing to or not agreeing to discharge or grant of bail.
My lord.
But you know, the judgment in K. Najib,
My
the
lord.
judgment in Watali, the explanations, they all point towards two things.
My lord.
That in the national interest, this is constitutional. There is no unconstitutionality attached to it. It should be administered appropriately. What would prima facie mean?
My lord.
Prima facie true.
Unless it is rebutted. Unless it is rebuted. Now, my aspect is
But
that,
yes, you give your notes of argument. We will take it into account.
my lord, your lordship will
We
kindly.
are,
I have given my compilation.
we don't want to give an impression that we are hearing with a closed mind. But we have dealt with this matter in several cases, and we have also seen the judgments of the Supreme Court in succession, where this question was never raised. Even if not raised, the arguments were taken into account where the constitutionality was upheld. Otherwise, in K. Najib, there was full occasion for the Supreme Court to have said that this is bad, like they did it in that case.
Watali.
No, not in Watali. The other case where it
Vernon.
was Tarachand Nikesh Shah, where it was struck down. So I don't think you can make out a case, especially in national interest. You know, we have.
No, I am not saying that 43D5 has to go down. I am saying only you're restricting to the case diary and the search sheet. For example, your lordship, today you file a bail application, the court will be restricted to charge sheet and the case diary. Now the charges are framed and the evidence get diluted. I come and file a bail application, then the precarious condition is that the learned special court will be restricting only to the charge sheet and the case diary.
Yes, Ms. Gyan, are you ready? Government counsel should be ready in all matters.
Because that is why when this notice was issued, my lord at that time, your lordship at that time, Honorable Justice Mehta, opined that we might have to read down. I said that it cannot be read down also.
Now, you don't make such a statement putting words in the mouth of.
No, I'm not putting,
Justice
I'm not putting, my lord. I'm not putting. Because
We have our immense respect for our predecessors. You possibly can't say that.
if your lordship, I'm offended, I'm sorry, but my.
No, not offended. We are only telling you about propriety.
No.
If it is not in black and white, please don't say that this was the observation of the bench. Or you should be careful in not taking the name of the judge.
My lord. Lordship, that is my.
Unless it is penned down.
My lord. What my submission is that 43D5, we restricting only to the part that only the case diary and the 173, that is the charge sheet, has to be referred. Because there is no analogous provision that has been referred by the Supreme Court in Gurvinder Singh's case, which I would like to take it down. That is what I am saying, your lordship. Kindly come to page 2 of my compilation. Sorry, page 6, my lord.
I don't think it's. Yeah. Yes.
Page 6. My lord, illustration. Suppose an individual X is arrested and prosecuted by the state for offences under Chapter 4 and 6 of the Act of 1967. Mr. X intends to file a bail application. So, in the present scheme of the proviso, the court will peruse the CD if the case is still under investigation. If the investigation agency has filed the final report under 173 of the code, then the court will peruse the final report only. Hence, the court cannot look anything beyond the case diary or the final report under 173 of the code.
And what is the material that you wish the court to see in such circumstances? Your defense.
My lord, I cannot bring any defense because statute has restricted.
You cannot otherwise also.
So, when the trial proceeds and the evidences get diluted, kindly see the second illustration. Kindly see the second illustration.
Yes.
Evidence हो गया, कुछ material मेरे against नहीं है, whether I apply a bail, that will not be.
There's no complete bar. This is just a check. Anyway, this you argue. Finish it. Okay.
Your lordship.
You're facing a rough weather, we know, but then this is
Your lordship.
this is the consistent view of the Supreme Court.
My lord, your lordship, I will take your lordship to kindly come to your lordship as already viewed. My argument is that 43D5.
The better option for you is to knock the doors of the Supreme Court.
Because we went to the Supreme Court. Already the matter was pending in the Supreme Court, so we went. Because the Supreme Court said that if any pending matter is there in other high courts, the government has to inform them. But in our case, this matter was not being informed. So we filed an IA for intervention. Then the Supreme Court said that all the matters will go to the respective high courts. That I have annexed in the order sheet.
And that we know. That is particularly with respect to Delhi High Court.
No, my lord, not in only respect to Delhi High Courts.
Now give us any judgment of any other court which goes to the contrary or which accepts your view.
No one has gone into it till now. No one has gone into it. Nobody has raised this issue.
We will give you. We'll be delighted to give you a judgment on this.
My lord, your lordship, if your lordship has made a view, honorable this court has taken a view that for national interest, this is there.
That has weighed very heavily with us.
National interest is paramount. But the question is that what Watali says or Nazif says, only with respect to
Mr.
Article 21.
Borgohain, you should, I am not asking you to give credit to us, but we have dealt with such matters in different jurisdiction where this law was necessary. We don't want to say many things.
I am, with all humility in my command, I must say,
And in one of the matters where a police officer who had worked with the state of Bihar for about 35 years, and thereafter it was found that he was a sleeper cell, and then he was arrested. And there was another advocate who was hopping around in the entire length and breadth of the country in various high courts, asking for bail for all those accused persons. All of them were prosecuted. I granted bail to them. And that was affirmed also by the Supreme Court, holding that national interest is very important, but evidence has to be seen. And what is the material? It's a pre-investigation material or post-investigation material. And they say in K. Najib, the only ground on which bail was granted was the continuance of the trial. In Watali, they say that no, the court, the Delhi High Court went beyond. It was a
appreciating the evidence.
trial. Correct. That is true in other cases also. Suppose in a case of 389(1), forget about this.
Hello.
And this, in fact, in Watali, if we remember, Justice Khanwilkar has gone to the extent of saying that this requirement is lighter compared to what you find in
NDPS on other states.
NDPS or other sections.
No, no,
Therefore, we have not made a view just of our own. We have made a view on seeing the case law, on seeing the circumstances, and on going through the principles which are. So, if what the better option would be, let us not get into an argument which is unending. Now, you give your notes of arguments.
I've given my notes.
You have given your
My
notes. So, we will decide. What do you have to say?
But the deputy solicitor was supposed to respond.
Call him because he has already filed the affidavit also, man. He has filed.
He has filed the affidavit.
Yes, ma'am.
All right. Arguments heard. We have arguments heard, judgment reserved.
Obliged, sir.
You have, we don't question your propriety.
No, no. I would like to give an example if my lords agree for 1 minute.
Initially, we thought that you are unnecessarily agitating an issue which has already been decided. But when we went through the records, now you are justified in filing this petition because this issue was never raised.
Never raised.
Yes, correct. Correct. So we are not questioning that, but let us see. We are open while framing our opinion. We might consider.
No, of course. I mean, if I'm offended, the word which I used, that I referred to your lordships, that notice, judicial notice or remand may taken into consideration. I'm sorry for that. With my own humility.
What happened?
No. I referring to your predecessors. It just came up. I'm sorry for that.
All right.
I'm sorry for that.
All right. Doesn't matter. You never intended.
I never intended to do that.
Question is this. Now we show a lot of respect and it is required
My lord.
to the predecessor. If you say that it was his view, then it will take a very strong grounds for us not to go by that view. So therefore, never to take that statement. Correct. This is how people learn, no? This is how, you see the Hyderabad incident. Yes.
Obliged, sir.
Item 14.
Absorption.
The matter relates to counting of past service following deputation.
No, see, Mr. Chaudhary.
Yes.
Though we have noted down your argument on the last occasion on
Yes.
20th of November 2025.
Yes.
See, you get absorbed from a particular date.
Yes.
Now, where is the objection or where is the apprehension that your past service would be effaced because you were in government?
Because the order itself says.
No, it doesn't, does it?
Yes.
But you were in government, no?
No, I'm not the government.
You were in the government.
Ah,
तो कैसे effaced हो जाएगा? I don't
Yeah.
think so.
yeah.
No, let's see.
Lordship knows this
The
fundamental.
contention of the appellant is that treating his absorption from the year 2016 would be prejudicial to him.
Yes.
But in case it is found that this absorption was only an interdepartmental transfer without impinging on the pensionary benefit later, the date would not be relevant.
Yes.
So how do you say? What is your stand, Mr.? आपने पहले समझा क्या कोर्ट ने मांगा है आपसे?
Your lordship, their file is processing and taking the opinions of different departments.
You're taking?
Opinion of different
I don't think you can do that for the reason that he is a government employee. He has been absorbed in a department. He did not choose of his own. He was transferred. He later remained. He wanted to be repatriated. That was refused. So he became absorbed in a separate department. That is also a government job. वो ऐसा नहीं था. He was not in a private job or something. Anyway, you take instructions and tell us.
Yes.
As
No,
put it,
last time also, I think he was asked to obtain this.
today he is not ready. He can't answer. He has sought instructions.
Department. That is what he said.
If he says that it shall not be effaced, why will you press this?
Only thing is, Mullah, this is a known thing, Mullah, why they are.
You are still in service, no, Mr. Chaudhary?
Mullah,
You are still in service.
Yes, I have not retired.
Don't worry about it. Okay, as prayed for, ये क्या नाम है इसका? K. Kumar. As prayed for by Mr. K. Kumar, learned Additional Advocate General Assam. Have you followed what we have said?
Yes.
Because he joined which department? He joined Assam's irrigation department in 1994.
Yes.
He was deputed to the Panchayat and Rural Development Department in 1999
Yes.
as assistant project officer. Then he wanted to come back after some time. You refused. Then he was absorbed there. That became a separate department.
No.
So
He never
tried to.
Have you, then he never tried to or
tried
do
to
whatever,
revert
then
it
you will have to
itself the
respond.
Span department. He was insisting all through.
Suppose he was insisting also.
He was insisting.
Correct.
For
So
example,
are you intending
we
to?
repatriated him.
Mr. Kumar, please hear the court. That is not an issue whether it was of his interest,
Yes.
his volition, or you forced him.
Issue is not there.
That is not the question before us. Question is that he started working with the government in 1994. Would his services in the government not be considered when his case for pension would come for consideration? You have to just answer yes or no. We will decide. Ab samajh gaye?
Yes.
Now you follow. You give us one instruction. And if not, why? Which rule prohibits it? It's not a case of, regularization that from the cutoff date only you will be regularized. It's a case of interdepartmental transfer.
Yes.
It should not have come to the appellate stage.
It's a transfer only, my lord.
It should not have come to the appellate stage. You take instructions, get back to us.
It was never an issue in the writ proceeding also.
It was never?
It was not an issue in the writ proceeding.
Now we have raised this issue.
Why my writ petition was dismissed?
We have, just a
Because he
minute.
was claiming.
Mr. We have
he
raised
was
this.
claiming seniority in the absorbed post
Missed.
since the date of his deputation.
Therefore, that is one of the benefits which you would like to claim. But he may lose on that count. So far as his pensionary benefits is concerned, it's absolutely without question, unless you show any rule. So far as his seniority is concerned, I think that will be governed by the seniority of that organization where he is absorbed.
Yes.
So that is not an issue.
Here, my earlier argument, which Lordship has noted, I don't think Lordship has to go to that aspect.
That aspect we are not looking at. You tell us whether his government service would be counted or not. But Mr. Chaudhary, just a minute. But Mr. Chaudhary, why do we are not RTI people, no? Why do you want this? Just a minute. Why do you want this declaration from us?
That's why we are before a lordship.
Why do you want a declaration from us that it shall not be wiped out?
No, not because this is the, please have to look at this order.
Order says what? That is with respect to seniority.
Yes.
So,
Not
seniority is...
seniority, उस दिन से उसका effect होगा।
नहीं, although that will...
क्या instruction है सर इसको क्या instruction है? It will become on.
Page 114, my lord.
What does it say?
Yes. On his services being placed at the disposal of the Panchayat and Rural Development by Irrigation Department, Government of Assam, is hereby permanently absorbed against the vacant sanction post, which was created by so-and-so and retained permanently under establishment of the so-and-so, with the, as per, with effect from date of joining in the Rural Department, that is this date, my lord, 12/9/16.
Oh, ठीक है. That declaration would be required to be given. We are not going to touch on the seniority aspect.
Yes, yes.
Clear.
That is neither my prayer also, my lord.
Chalo. Take instructions, get back to us within 3 weeks. 3 weeks से ज्यादा चाहिए इसके लिए. कुछ बहुत नहीं लिखना है. 2 pages affidavit if you say no.
I think, my lord, my learned friend has taken at least 4 or 5 times. This is the 5th time, I think.
No, department is trying to help you, your lordship. Because it's a procedure, your lordship.
Mr. Kumar, please. Please don't
Procedure should
help.
not take 2
Please
years.
don't. Administrators are not there to help people. Administrators are there to decide. Leave that job of helping to us. You decide. You say that it is not done because of this rules. We'll say, we'll assess, we'll evaluate.
The thing is that the department is moving at.
You want 4 weeks, we give you 4 weeks, but don't unnecessarily justify. As prayed for by Mr. Kumar, Learned Additional Advocate General, Assam, let this matter come up for consideration under the same heading on. Give after 4 weeks on a Thursday.
Thursday. 11 June.
Yes.
Alright.
Item 15.
The validity of anti-defection law enacted by the NCLs of the Council.
By our High Court in 3 judgments, which they are relying.
Very fair.
No opinion to make.
No
Already
opinion.
settled.
See, I was only thinking that, clause 6. Disqualification due to defection.
Lordship.
This in pith and substance would be relatable to 3 of the topics in subparagraph 4. That is one ground which can give at best, Mr. Das can argue on that. You can argue on that at best. Pith and substance. Next, pharmaceuticals, you remember. Judgment by Justice B.P. Sinha. That was with respect to article.
Because the same issue was decided in the coordinate judgments. That is
And
why I
the
did not.
bill is pending in Supreme Court.
Yes, Lord, sir. That also gives an indication that it is not within the domain of the council at this stage.
But once an idea comes to my mind,
I sought several adjournments only to explore if something can be argued.
No, you can argue. You can argue. The only ground which is against you is that with respect to defection, there is a constitutional amendment by way of 10th schedule. Therefore, whether this law would be within the legislative field or it is a constitutionally structured mechanism. If it is a constitutionally structured mechanism, I don't think they can, the Autonomous Council can make a law. What we were thinking that from one of your affidavits, that was very insightful. I remembered my old learning days of law faculty. Come to page 55. Interesting. Page 54.
Yes.
You have come to page 54?
Yes, Lord.
Last A. With the autonomous district or regions, the subjects on which law could be made, the composition of district council, regional councils, and allocation of seats. Then come delimitation of territorial constituencies for the purpose of election to those councils. Then 3, the qualifications for voting at such elections and the preparation for electoral rolls. Next, the qualifications for being elected at such selection. This inheres in it the qualifications for disqualification, the terms of office of members of such council, and F, any other matter relating to or connected with elections or nominations to such council. So
This I can take help of, but as there is the same issue is because these banks may not be able to do it, Lord. It has to go to the full bench, then I can definitely argue.
इस पे एक ही बहस है आपकी कि it is neither incidental nor necessary for conducting elections. Therefore, even in pith and substance, it will not come because there is a judgment. I also don't want to do it, but
Yes,
we could have argued.
2009 judgment.
Where is that judgment? Mr. Das was giving some judgment.
We have given some writing.
Justice Bhaipen, Justice Bhaipen, that is 2009.
There is Khasi Autonomous Council or something.
Larger bench में है?
Yes, H. Sela versus Khasi Autonomous. District.
Larger bench में है? You want to argue this? We can send it to a larger bench.
I like to argue. Lord.
सोच लीजिए आप. You take because this can be argued. Now let us see the reasoning of that judgment.
No, it's simply
नहीं तब कैसे?
This pith and substance is not a part of the judgment. This is simply done under the power.
Competence.
आप बोलिए, this is your call. I leave the ball in your court. Whether you would like to go by Mr. Das,
I'd like to argue.
हाँ, उसको बहस करिए. Hex Pharmaceuticals से देखिए. These are interesting things. Nothing is going to happen now. Let's see. We might agree to that view. Otherwise, we'll send it to a larger bench.
I have not prepared for that.
आज नहीं बहस करिए ना. Any take time.
Supreme Court decision is also there, judgment is there.
Supreme Court judgment is there. Then we will.
Supreme Court.
Which Supreme Court?
Let's see one.
Supreme Court judgment है तो फिर कुछ नहीं करेंगे.
Yes, 71 Supreme Court.
क्या है?
They made a law on transfer of land. Court said
नहीं वो. That is not the issue.
The exact.
Us don't get afraid by our observations. It is easier for us to decide your way.
I understand.
Well,
But
this is
court
High Court.
ultimately
This
said that-
is a new High Court. Why can't we explore the grounds?
Court
Take
says
your
that
time,
ultimate-
after about 4 weeks, we will.
Lordship, first week of June, any day after first June.
It will be before
Who
the
is getting disqualified, Mr. Das?
I don't know that one. We have.
It is required, actually, it is very much essential.
What I am saying is that my lord.
Election क्यों नहीं होगा?
That is the argument.
And there are two arguments against you. Against you if you take a different stand. One, 10th schedule talks about disqualification. This law which has been made by this autonomous council is exact replica of 10th schedule. So if 10th schedule is by parliament, then it is constitutionally structured. It is not in the legislative field. Correct. That's a very strong logic. The second is that parliament has introduced a bill which has not been acted upon.
That actually diffused my intention.
But ये बहस अगर करें तो under paragraph 6, by applying the doctrine of pith and substance, if qualification, अच्छा किसी की appointment की rules होती है तो उसमें dismissal का होता है कि नहीं होता है?
My lord, all the findings says, my lord, they are elected for 5 years. You can't disturb that by electing.
So if the
Pith and substance of the
So-
judgments.
pith and substance will not come.
The substance, my lord, the court said that they are elected.
No,
for
no,
5
pith
years.
and
You can't
substance with
disturb
respect
by
to the powers,
powers.
with respect to the
principle of-
entries.
Principle of.
Principle of pith and substance. So under that any matter related to election, उस पर नहीं आएगा?
नहीं, कैसे?
क्यों नहीं आएगा? Anyway, we will.
If you reduce
The
the.
easier course is to allow his appeal. आप बोलिए उसको कर दें. We allow. We turn it down.
Let it be allowed.
हाँ चलिए. The application is allowed. लिख लेना हमसे अभी. तो अभी लिखाएंगे. The petition is allowed. It is held as unconstitutional. Give us that judgment.
Already they have given
नहीं,
us.
हाँ, हमारे फाइल में नहीं.
Take. Earlier there was a set of.
Give another copy, Mr. Das.
No, it is the written.
Dictate the judgment in
Written
chambers.
submission.
Given the gist of the judgments also and the.
भाई पेगा judgment ऐसे. इसमें कोई Hex pharmaceuticals and all, nothing has been discussed.
Nothing, no. This was not argued also, whatever point Lordship has indicated. Some additional points are definitely there.
When our advocate general is saying that it is to be allowed, let it be allowed. चलो, हटाइए.
I got, because that's parliament also,
It is
that bill.
Yeah, correct. Okay. Okay.
So intention of the legislature is very clear that it is not within the domain. That is why they mooted that idea of having a bill regarding anti-defection law in the.
But your affidavit by an IAS officer is very good.
Yes, Lordship.
It's a well drafted affidavit. That gave me the idea. That's the way affidavit should be drafted. Clear? Without any dis. Chalo, ठीक है. All right, hearing.
Deeply obliged.
All right.
16 and 17.
Mr. Kamar hai.
Lordship, in this case, I was provided with a copies of 2 volumes of paper book, your Lordship, but that is not complete. Not complete in the sense the sentencing order is not part of that particular. That's that one
step.
And it was handed over to me day
Who is
before
responsible?
yesterday.
No, he has been given, handed over. He has been handed over day before yesterday.
Day before yesterday.
Oh, ठीक है. You want a time?
I want some time and I also want to place one order, your Lordship, recent order of the Honorable Apex Court, your Lordship. Probably this may have to.
That's for a date reference, date
That
part,
reference, your Lordship.
mitigating and
Report
aggravating.
pertaining to aggravating and.
We
We know that, that has been said.
We know about that. That judgment
Lordship.
by Justice Uday Lalit.
No, not
No, no.
the Lordship, your Lordship. This is very recent.
Vikram.
This is by Bikram Nath and Honorable Justice Sandeep Man.
As prayed for by Mr. Santanu Bhattakur and senior advocate for the appellant. Let this matter come up for consideration on दूसरा वाला death reference कब रखा है?
19.5.
On 19 we have kept it. तो उसको रखते this we keep on 19 को रखा है, then we keep it on 26th.
Lordship. In the meanwhile, a copy may be served on your paper.
In the meanwhile, let us not say anything.
Hey, all copies should be served to everyone.
It's 4:30.
They choose.
So 26.
Yes,
26.5.
No, we understood. But your colleague was here. Can you give it to us? वो उसमें रख दो.
Otherwise, basically the same judgment is in addition to he says that in these particular cases, there is the exception and not the criteria are achieved. Otherwise, one paragraph from this judgment that will cite.
Yes.